Get your things. Chandler Rowe didn't look up from his phone when he said it. That was the detail Nia Harmon would remember most. Not the words, but the fact that her firing wasn't important enough to interrupt whatever he was reading. "Sir, may I ask why?" "You may not." He set the phone down then, but only because he wanted to look at her directly while he finished. 9 years. I've been reviewing this firm's billing records for 2 weeks, and 9 years of your output amounts to document warehousing. What the partners thought you were doing," he shrugged with one shoulder, "is a story you told well. I'll give you credit for that much." He slid an envelope across the desk. "Security will walk you out." The Dellaway case. Nia's voice was level. Not a plea, a statement of record. The framework, the evidence architecture, the witness strategy. I built all of that. We have a Harvard-trained litigator ready to take it to trial. He folded his hands. What we don't have is a need for someone who's been making herself indispensable to people who didn't look closely enough. He rose from his chair. "Clear your office by noon." Nia looked at the envelope. She looked at the floor-to-ceiling windows behind him. Chicago under an October sky, gray and stripped of color, the lake invisible in the haze. She picked up the envelope and left. But in 23 days, the woman Chandler Rowe called a document manager would be the only person alive who could keep his firm from losing a $40 million case, its founding client, and everything they'd built on a framework they'd never known she owned. If you've ever watched someone walk into a room they weren't supposed to be in and make everyone who dismissed them go completely silent, stay with me, because that's exactly where this is going. The parking garage was cold. Nia sat in her 2014 Accord for 11 minutes before she started the engine. Not because she was falling apart, because she was calculating. The trial date was November 14th. 23 days. The Dellaway plaintiffs, 214 workers who had been systematically passed over, demoted and pushed out of Carver Industrial over 8 years, had waited 3 years for this case. Some had burned through savings. Some had lost home. One, a man named Raymond Dube, had 3 kids at home and an 11-year employment record that Carver Industrial had erased in a 10-minute HR meeting. He needed this case to end. He needed it to win. Nia drove home on autopilot. She called her daughter from the driveway. "Mom, why are you calling from outside?" "Just checking in, baby." Did something happen? Kala was 11. She had her mother's instincts, which meant she could read a tone of voice the way a musician reads a key change, instantly, without being told. "I'm coming in. We'll talk. Do you want to make hot chocolate?" A pause. "The good kind with the actual chocolate bar?" "Yeah, the good kind." She sat at the kitchen table that night after Kala was asleep with a legal pad, a pen, and the documents she'd cleared from her office in a cardboard box she'd had to ask security for, because she'd never thought she would need one. She wrote down the numbers, her savings, the mortgage, Kala's tuition at the academy. A partial scholarship covered 2/3, which meant 1/3 was hers. Her mother's insulin, which had gone up again, the car payment. 11 weeks. That was what she had between herself and the kind of trouble that doesn't announce itself before it arrives. She looked at the cardboard box on the counter. Then she thought about Rosa. Rosa Harmon had run a one-woman notary and legal document service out of a converted beauty shop in Gary, Indiana for 31 years. She was not a lawyer. She had a GED and a filing system that took up 4 of the shop's 6 walls. One she could navigate in the dark if necessary. What she actually did underneath the notarizations and the forms was help people understand what was happening to them. Workers who didn't know they'd signed away their right to sue. Tenants who didn't know they had a claim. Families who didn't know the bank was in violation. She couldn't file. She couldn't argue. But she could read, and she could explain, and she could tell you exactly what to bring and who to call. "You don't argue with people who underestimate you," Rosa used to say, sitting behind the counter with her reading glasses pushed up on her head. "You let the work speak for you, but you make sure the work has a voice." Nia had heard that sentence at 8 years old. She'd heard it again at 22, in her first year at the University of Chicago Law School, when a professor had told her that her analysis was impressively intuitive for someone from her background. She heard it at 34, when she'd submitted what would become known in civil rights law as the Harmon Brief, published under the name N. Harmon, not to hide, but because she'd wanted the work judged on its structure rather than on who wrote it. She'd been right. The brief had been adopted as the theoretical backbone of employment discrimination class action strategy in 7 federal circuits. Every serious civil rights litigator in the country had read it. Half of them taught it. The firm that had just fired her was paying a licensing fee to use it. That was the part Nia let sit with her at the kitchen table for a long moment before she picked up her pen and went back to the numbers. 12 months before Chandler Rowe arrived at Mercer Rowe, the firm had been a different kind of place. Lawrence Pickett had run it for 28 years. He was the kind of man who evaluated people the way a structural engineer evaluates a building, not by how it looked but by what it could hold. He'd brought Nia in after reading a 70-page litigation analysis she'd submitted as part of a pro bono consulting project. He called her on a Tuesday. By Thursday, she had an office on the 14th floor. Over 9 years, Nia built the Delaware case the way her grandmother had built her filing system, from the ground up, one document at a time, until the architecture was so comprehensive that removing a single piece would shift the whole structure. She interviewed the plaintiffs herself. 214 workers, in their homes, in church basements, in hospital waiting rooms. She documented their hiring dates, their performance reviews, their promotion timelines, and set them against those of their white counterparts with equivalent or lesser qualifications. She built a data model that showed not just individual instances of discrimination, but a system, a deliberate, recursive pattern that had been running at Carver Industrial for 8 years with full knowledge at the executive level. She called it the grid. Nobody else called it anything. To the partners, it was the Delaware materials. To the associates, it was the binders. Nobody fully understood the architecture except Nia, because nobody else had built it. Meredith Cross, one of the firm's equity partners, had come to Nia's office 6 weeks before the firing and stood in the doorway with her arms crossed. "He's going to do it, Nia. I've seen his assessment notes. He thinks you're overhead." "I know. I can push back, but I don't have the votes." "You're not the first person he's moved against." Nia set down her pen. Darlene Webb, Samuel Kim, Tomas Acevedo. She named them without looking up from the page. Darlene had been in the firm's community outreach division, 31 years old, the only black woman among the non-attorney professional staff. Samuel Kim had run the firm's forensic accounting team for 6 years, with a record that needed no defense. Tomas Acevedo had been the paralegal coordinator. 16 years of institutional knowledge, walked out in a cardboard box, just like Nia's would be 3 weeks later. All 3 replaced immediately. All 3 replacements with better-sounding credentials and less experience and no understanding of the cases they'd inherited. Meredith was quiet. "Go back to your office," Nia said gently. "You've got a family. Don't burn yourself down over this." What Nia did not tell Meredith, because it wasn't time, because things had to get worse before they could get better, because Rosa had taught her that timing was everything and you didn't show your hand until the last card was already on the table, was what she had done 6 months earlier when she'd first read Which Way the Wind Was Blowing. She had filed an addendum. Not in any system accessible to the firm's internal case management database. She had filed it directly with the federal court clerk for the Northern District of Illinois, sealed, under a docket designation that would only activate upon written request from lead counsel. The addendum contained a secondary theory of the case that no one else knew existed. While the primary Delaware suit was built on employment discrimination, Nia had spent the final year of her tenure documenting something else entirely, something she'd noticed first as an anomaly, then a pattern, then as what it actually was: deliberate misrepresentation in Carver Industrial's annual SEC filings. For 8 years, Carver had certified to the Securities and Exchange Commission that it was in full compliance with federal equal employment opportunity laws. It was not. It had never been. The certification was false, filed knowingly, and the company's stock price had been artificially supported by the appearance of regulatory compliance. The secondary claim wasn't just a civil rights case. It was securities fraud, and it was worth 10 times the original suit. Nobody at Mercer Rowe knew the addendum existed. Nobody at Mercer Rowe knew what Nia Harmon's first name was. It took exactly 16 days. Day 8. Trevor Ashe, 29 years old, Harvard Law, author of 3 law review articles on digital discrimination theory, could not locate the deposition cross-reference files that Nia had organized into what she called the Echo Index, a nonlinear filing structure that mapped each witness statement against the corresponding documentary evidence and the specific claims it was built to support. Trevor had been told the files were in the case management system. They were. He just couldn't navigate the architecture because he'd never been shown how Nia had built it, and there was no manual because the work had been designed to speak for itself. It couldn't speak to Trevor Ashe. Day 11. 3 plaintiffs reported receiving calls from Carver Industrial's attorneys suggesting the case timeline was under reassessment and that they might consider a private settlement. One of them called Nia directly. Mrs. Harmon. His voice was controlled in the way that voices are controlled when the person speaking them is fighting to stay that way. What's happening with our case? I'm aware, Nia said. I'm watching. But you're not at the firm anymore. No. Then who's watching for us? She didn't answer that. She said, don't settle. Whatever they offer you, don't settle. Give me 1 more week. Day 14. The Honorable Catherine Aldridge, presiding federal judge, issued a written order noting the apparent disorganization of the plaintiff's evidentiary presentation in recent pre-trial filings and warning that continued failure to meet procedural standards could result in sanctions. Judge Aldridge's warnings were not decorative. Day 16. Meredith Cross called an emergency partners meeting. Lawrence Pickett was retired. He had an equity stake and a standing commitment to stay out of operational decisions since handing over management. He came back for this one. He sat at the head of the conference table at 6 in the morning and listened to everything without speaking. Then he turned to Chandler. Who built the Delaware case? Nia Harmon was the primary case manager. I didn't ask you to interpret the question. Who built the Delaware case? The evidence architecture? The witness preparation? The filing framework? Meredith answered before Chandler could reroute it. She built the grid. Every piece of evidence, every witness statement, every filing cross-referenced to 3 other points in the case. Trevor has been working for 8 days and cannot locate a third of the evidentiary files because he doesn't know how the system thinks. He's never been shown. There's no manual. Nobody wrote one because nobody else built it. There was one other person in the room who had been sitting very still since the meeting began. Gerald Asante had been brought in 2 days earlier as an outside litigation consultant, Meredith's idea, brought in quietly before the emergency meeting was formally called. He was 64. He had taught civil rights litigation at Northwestern for 20 years. He had argued 4 cases before the Supreme Court and written the textbook that every serious employment discrimination attorney in the country kept on their shelf. He had spent 2 days with the Delaware materials. He had not said anything yet this morning. Now he spoke. Can someone tell me who Nia Harmon is? The table was silent. The case architecture, the cross-referencing methodology, the evidence synthesis structure. It's the Harmon framework. I've been teaching it for 15 years. I know it the way I know my own handwriting. He paused. Nia Harmon wrote the 2009 brief that established the grid methodology as a viable litigation framework for systemic discrimination claims. 7 circuits adopted it. I pay a licensing fee to include it in my curriculum. I have been trying to find Nia Harmon for over a decade. I assumed it was a man. I assumed he was retired. He turned to Meredith. The woman you just described. Where is she right now? If you've been watching this far, and something in your chest is tight in a way you recognize, like you've been in that conference room, like you've been the one who built the thing and watched someone else not understand what it was, then you already know what this moment means. Don't go anywhere. Meredith Cross called Nia at 7:14 in the morning. Nia was in her neighbor's driveway, flat on her back under a Chevy pickup with a ratchet in her hand and motor oil on her knuckles. It was the 3rd car she'd worked on that week. She wiped her hands on a rag and answered. Nia. Meredith's voice was pulled taut. Gerald Asante is in the conference room. He knows what you wrote. He knows what N. Harmon wrote, Nia said. He doesn't know me. He wants to. The case is dying. Raymond Dube called me last night. He was crying, Nia. Nia lay still for a moment beneath the truck. She looked up at the undercarriage, at the rust along the frame, the honest evidence of age and use, and she thought about Rosa's cabinet in the corner of the beauty shop, the locked one where she stored documents for people who couldn't come back to pick them up because they'd already lost too much. The file doesn't care about my feelings. The file is for them. I'll come, Nia said, but I have conditions. Name them. I walk through the front entrance, same as anyone else, no side door, no quiet hallway, lobby, elevator, 14th floor. Done. Trevor Ashe stays in the room for every conversation. I want him present for all of it. Done. And Chandler Rowe issues written apologies to Darlene Webb, Samuel Kim, and Tomas Acevedo. Personal letters on firm letterhead acknowledging their terminations were not conducted with proper review. They don't have to come back, but they get the acknowledgement. A long pause, then Meredith said, "Done." Lawrence Pickett just nodded. Nia arrived at Mercer Rowe at 9 o'clock. She wore the same cardigan she'd worn the day she was fired. Flat shoes, her reading glasses on a chain around her neck. She carried a canvas tote bag with Gary Public Library printed on the side, because it was the bag she had and she saw no reason to carry something else. The lobby security officer, a man named George who had worked the desk for 11 years and who had slid her a bottle of water the day she'd been walked out without a word, saw her come through the revolving door and stood up straighter. She nodded at him. He nodded back. It was a small thing. It was not a small thing. The elevator opened on the 21st floor. Lawrence Pickett was waiting at the conference room door. He extended his hand. His grip was the grip of a man who looked directly at the person he was speaking to. "Mrs. Harmon, thank you for coming." In the far corner, behind two associates, Chandler Rowe stood with his arms crossed, and the expression of a man enduring a weather event he hadn't forecasted. Gerald Asante rose from his chair when she entered. 40 years of litigation had given him a face that processed information without visibly reacting, but when he looked at Nia Harmon, at her cardigan and her library bag and her reading glasses on their chain, something shifted behind his eyes. Something that had been oriented one direction quietly recalibrated. "You wrote the 2009 brief," he said, not a question. "Yes." N. Harmon. "Nia. My grandmother's name was Rosa. I published under her initial for the first filing and the name stayed." Asante was quiet for a moment. When he spoke, his voice had the weight of someone making a formal statement. "I assigned that brief to first-year law students for 11 years. I told them, whoever wrote this understood something about systemic evidence that most litigators spend 20 years learning, if they learn it at all." He paused. "I want to be precise about what I'm about to say to this room. I have practiced and taught civil rights law for 4 decades. The Delaware case, as Harmon has structured it, is the most comprehensive systemic discrimination litigation framework I have reviewed in my career. What is in those binders is not case management. It is architecture, and what has been done to it over the past 16 days, he looked at Trevor Ashe, who was the color of old concrete, is the work of someone who did not understand what he was holding." The room was still. Nia set her canvas bag on the table. She removed a single manila folder and placed it in the center. "There's one more thing," she said. She explained the addendum. She explained what she had found in Carver Industrial's SEC filings, 8 years of false certification, a documented gap between the company's representations to federal regulators and what its internal employment records showed. She spoke for 11 minutes without notes. When she finished, the silence in the room was the kind that follows something irrevocable. Asante opened the folder and read the first 2 pages. He turned them slowly. He read them again. "You filed this sealed 6 months ago, under conditions that activate upon written request from lid counsel, which means it exists on the federal docket, cannot be suppressed, and Carver Industrial has no idea it's coming." "Correct. This isn't a discrimination case anymore." Asante set the folder down. "This is a securities fraud action with civil rights dimensions." The federal exposure alone is— He paused, because the number was large enough that saying it quickly would make it sound like exaggeration— substantial. Lawrence Pickett had been standing at the back of the room. He walked forward now, slowly, with the particular gravity of a man who had built something over 28 years and knew down to the foundation what it was worth. He stopped in front of Chandler Rowe. "You terminated the woman who built this case." His voice was quiet. It didn't need to be loud. "In 4 minutes. I've seen the calendar record. 4 minutes, Chandler." She was overhead. Analytically, the billing structure. She is the case that represents 40% of this firm's civil rights revenue, the case that 214 people have been waiting 3 years for, the case that is now, because of a sealed addendum she filed on her own time without being asked, potentially the most significant civil rights and securities enforcement action this firm will ever be associated with. He let the sentence arrive completely. "You looked at her and saw what was missing. You missed everything that was there." Chandler opened his mouth. Pickett raised one hand. It was not hostile. It was the gesture of a man who has run out of patience, not in anger, but in the particular way of someone who has seen enough clearly to know that no further discussion will change the shape of what happened. "This conversation is done. The board convenes at 2 o'clock. Nia spent the next 3 hours in the conference room with Gerald Asante and Meredith Cross and a whiteboard. She walked them through the grid. She walked Trevor Ash through the Echo Index, slowly and without condescension, the way Rosa had walked her through the filing cabinet in the beauty shop when she was 8 years old. Here is what it holds. Here is why it's organized this way. Here is the logic underneath the logic. Trevor listened. He didn't interrupt. When Nia asked if he had questions, he said, "I should have asked you to show me this on the first day." "Yes," Nia said, "you should have." She capped her marker. "You're not a bad attorney, Trevor. You're just not a humble one. You walked in here carrying your credentials like they were the answer. The answer was already in the room before you got here." She looked at him directly, not unkindly. "Next time someone offers to show you how something works, let them finish." The board convened at 2 and adjourned at 4:15. Chandler Rowe's tenure as managing partner ended at 4:16. The formal documentation cited operational mismanagement and a pattern of personnel decisions that failed to account for institutional knowledge. Those were the clean words. In the hallways and the parking garage and the coffee shop 2 blocks away, where associates gathered in low voices, the real words were simpler. He looked at her and didn't see her. And it cost them everything. The internal review that followed was methodical. In 11 weeks, Chandler had terminated 7 employees. 5 were people of color. 2 were women over 45 with more than a decade of tenure each. Their replacements, in every case, carried higher salaries and less experience and metrics that had declined in every affected department since the transitions. The pattern had a shape. Everyone who had been watching without speaking could name it. Chandler's severance agreement, originally drafted at $900,000, was voided under the misconduct clause in paragraph 11 of his employment contract. His attorney filed a formal objection. The firm's legal team responded with the sealed addendum documentation, Meredith Cross's archive of flagged person's decisions, and written statements from 6 of the terminated employees. The objection was withdrawn within 5 business days. Darlene Webb received a call on a Wednesday. She was at her daughter's soccer practice when the number came through, and she almost didn't answer. She answered. Samuel Kim listened to the entire call without speaking. When it was done, he asked one question. "Is this real?" It was. He said he needed a day. He came back. Tomas Acevedo returned on a Monday and spent his first 3 hours reorganizing the paralegal intake system, which had apparently been in slow freefall since the week he'd left. Nobody asked him to start there. He just saw it and started, the way people who understand a system always do when they see it suffering. Not everyone returned. Some had rebuilt elsewhere. Some couldn't walk back through those doors, because what had been done to them left a mark that proximity could reopen, and they knew themselves well enough to know it. That was a truth Nia held carefully, without pretending it resolved cleanly. Some injuries earn the right to stay where they are. What resolved was the case. The Delaware trial began on November 14th. It ran for 18 days. Nia Harmon served as lead co-counsel alongside Gerald Asante. The grid performed exactly as it had been designed to perform. The Echo Index made their evidentiary presentation the most precisely cross-referenced submission. Judge Catherine Aldridge later said she had encountered in 14 years on the federal bench. The sealed addendum, activated on day 3, brought a parallel SEC investigation that was not quiet and was not quick and was exactly as damaging as Nia had calculated it would be when she'd filed it alone at her desk on an April evening 18 months before the trial. Carver Industrial settled on the morning of day 19. 214 plaintiffs received compensation. The total exceeded the original suit by a factor Nia had anticipated within 3% when she'd built the secondary claim. Raymond Dube called her from the courthouse steps while she was still inside, still in her coat, her library bag over her shoulder. "Mrs. Harmon." "Mr. Dube." A long pause. She could hear wind on his end, people talking, the distant sound of traffic, and below it what sounded like a child laughing. "My kids are here," he said. "I brought them today. I wanted them to see how it ended." Nia stood in the corridor and said nothing, because there wasn't anything to say that the moment wasn't already saying. "Thank you," he said. It was simple. It was enough. 6 months later, in the Northwestern Law Review, a paper appeared under the name Nia Harmon, full name, not initial, titled "The Grid as Testimony, Systemic Evidence and the Architecture of Discrimination Claims." The co-author was Gerald Asante. In his introduction, Asante wrote, "For 12 years I taught a brief without knowing who wrote it. When I finally met N. Harmon, I understood immediately why she had published under a partial name. She had always known that some rooms only let the work in if the work arrives alone. She built the framework in that spirit. She built it so it could speak for itself. It does." On Nia's desk, next to a photograph of Kala standing beside a working water filtration model she'd designed entirely on her own for the school science fair. First place, judge's commendation, the whole thing, sat a worn green jacket with Rosa stitched in yellow thread on the left chest pocket. The only inheritance that had ever mattered. "Now I want to ask you something. Have you ever been the person in the room who built the thing, the system, the strategy, the structure that everything else depended on, and watched someone look right at you and see nothing? Leave a comment below. Tell me your story. I read every single one. If this moved you, share it with someone who's been underestimated. They need to hear it today. And if you're new here, hit that subscribe button because this is all we do.